Hi, everyone. This is Shelina Ali. I am a lawyer at Iler Campbell. I hope everyone's having a great afternoon. Welcome. What we're going to talk about today is how to get your message out without getting yourself in hot water. And this really just is about how you can use social media and the internet to communicate with the audience without getting into trouble with any legal liability. So here's the agenda. I'm just going to do a very brief cursory overview about what social media is. I'm sure everyone knows what it is, but doesn't hurt to review. And then we're going to go into kind of the main legal areas that you could get into trouble using social media for your organization. So there's privacy concerns, defamation issues, and then human rights. And then I will talk about some tips to use social media effectively and answer any questions. As a disclaimer, I'm providing legal information, so that's what the intention of this presentation is just to be informative and hopefully give you some insight into the issues. But I'm not providing legal advice and suggestions on specific issues that you're having in your organization. Anything can be really fact dependent. So if you feel like there's a concern that's raised as part of this presentation or a concern you have generally about a specific issue, you should talk to your lawyer. So briefly, what is social media? Social media is generally refers to platforms that allow users to create and share content with other users or participate in social networking. It's really a catch-all phrase to describe a set of online tools that foster this kind of interaction and discussion in community. Obviously, it can be in many different forms. So you have it in blogs, web pages, apps, messaging services, and it has a very far reach, which is great for promoting an organization or getting your message out to the general public or a subset of the population that you want to communicate with. So it's a very effective tool at doing that. And so some popular social media platforms today obviously include things like Facebook, so probably becoming less popular, Twitter, Snapchat, Instagram, LinkedIn, and all of these kind of platforms have several different options, right? You can post generally, you can do direct messaging, which is more between two people who are using the platform. And then you can have temporary posts, so posts that disappear within a set time period. So there are lots of different options about what kind of messages you can post on the platform as well. So what are the main legal concerns? And, I think most people generally focus in on defamation and the possible liability there. But there are a few different legal concerns that can arise when an organization or an individual uses to communicate with other people. And the first is intrusion upon seclusion, which is essentially a fairly new cause of action in Ontario. That's a privacy tort. So it's a cause of action in privacy. And since it's fairly new, so this has really been developing the last decade, there are a variety of cases that may give various tests for what it entails to invade someone's privacy through posting something or sharing something online. But generally, the general idea is that it involves giving publicity to a matter concerning the private life of another person, where publicizing the matter would be highly offensive to a reasonable person and also not a legitimate concern to the public. So really, you have to look at both aspects. So if you publicize something that is highly offensive to a reasonable person but may be in the legitimate interest of the public, then it wouldn't necessarily invading someone's privacy or intrusion upon seclusion. So generally this privacy tort has developed actually in the context of very unfortunately something called revenge porn. So, very salacious cases that discuss this. But it's also developed in, kind of a more innocuous context. So there was an Ottawa case that was from 2014, where the plaintiff in that case who sued under multiple grounds, but one of them included this privacy tort, was filmed jogging on a walking trail by a condominium developer in Ottawa. And then following, the plaintiff at the time had apparently, according to the facts of the case, had just given birth, so not probably not feeling great about her public image, and then, was videoed by this condominium developer. And in the editing process, appeared in the publicity video for marketing the units of the condominium for about 2 seconds. And so the plaintiff sued, was upset about the manner in which she was depicted in this video. And in that case, the court held that the plaintiff's privacy was breached in this case, and specifically because the court found that because this was a for-profit enterprise, that that was especially damaging in terms of how they used the plaintiff's likeness without consent. Even though she was in a public place, even though she was jogging, there was still an entitlement to the plaintiff to be concerned about how she was depicted, and a right to privacy and to not be in this video for-profit marketing purposes. And the plaintiff was awarded $4,000. And again, that was for a 2-second video. So something that quite a great deal of liability for. And then the other main legal issue that comes up, the main legal head, is defamation, which I'm sure most people are at least somewhat familiar with. There is a difference between libel and slander. And so in Ontario, under the law in Ontario, libel constitutes defamatory words that are actually published in a newspaper or broadcast. And so, a newspaper is actually very narrowly defined as a paper containing public news that is circulated and distributed to the public. Broadcasting, on the other hand, means dissemination in writing, signs, signals, pictures, sounds of all kinds to the public through means of wireless communication, cables, wires, fiber optic linkages, or laser beams. So obviously the broadcasting part is where defamation comes in. And so there's a question just about the privacy case that I discussed previously. Is for-profit the key phrase in the jogging example? In that case, the court really fixated on that, and I do think that it was significant in awarding damages, but I wouldn't necessarily bar that, bar liability for nonprofits just based on that case. I think that it's open to that, and I think it really would depend on the purpose that the nonprofit was using, the image or likeness or video that they've captured of an individual, what purpose they were using it for. Okay, so back to libel. So, obviously most social media cases would be in the libel part. Slander is quite different, and it involves words being spoken about someone to disparage their office, profession, trade, or business. So, issues with defamation on social media would not necessarily generally be considered slander because the words aren't spoken, they are broadcast. Defamation's second part is not only does the statement defamatory words have to be published, but they actually have to harm a person's reputation, which is an important part, right? If a person's reputation is already not great, then it probably wouldn't be harmed by certain defamatory words. And then the third part of defamation that you need to be concerned with is if there are any defenses available. And I'm going to get into the defenses later on in the presentation, but generally defenses include things like, well, if the statement was true to any defamatory post that you make, if you were commenting on something and it was fair, meaning that it was well balanced and thought out, then that's a protected right. You have freedom of speech, you're allowed to comment, and that is a full defense. Okay, and then the third legal obligation, third head of legal concerns around social media are human rights obligations. So as housing or service providers, you must provide equal treatment with respect to occupancy of accommodation or the provision of services, and that means that you have to provide services or accommodation that is free from harassment as defined in the Human Rights Code. And employers must also provide equal treatment with respect to employment and must provide employment free from harassment. And so how does this relate to social media posts? Well, employers and organizations do have an obligation to monitor what's being said in case what is being said or posted is creating an environment of harassment that would be contrary to what is required under the Human Rights Code. And I like talking about this co-op case that went to the Human Rights Tribunal, just in the context of explaining what could go wrong in terms of social media posts and human rights. And it was the Rouge Valley co-op case, and it was not a social media case. And so the facts of the case were that there were anonymous individuals in the co-op who were posting really offensive things about members of the co-op, and I'm not going to repeat them because they're terrible. And the tribunal did describe the messages as incredibly vicious and vulgar, truly heinous, and displaying a shocking level of ignorance and intolerance. So these messages were posted throughout the co-op for other members to see, including the members that were targeted by them. Those members applied to the tribunal for some relief, and the tribunal found that not only the cooperative but its individual board members were responsible for the campaign of harassment against the members because they did not respond appropriately, and awarded $3,000 each to the members and applicants. And that award was the board members, the individual board members, and the co-op were both liable to pay that award. So, the message in this case was that the co-op and the individual board members really needed to do something to appropriately respond to the harassment that was going on. And I like using this case because then you ask the question, just imagine if this was the co-op social media page and someone post media page. The dissemination of those messages would have been so much broader and the impact so much more profound. So that's really why it's important to always consider the human rights obligations when an organization is engaging with using social media or thinking about using social media for promoting their organization or communicating with the public. And then finally, just a non-legal concern that I like to mention is obviously reputation. So, there might not be any human rights obligations, there might not be any defamation issues, there might not be any privacy issues. But if, a poor message is communicated on social media, it obviously can harm organization's reputation. And so then we get to Marshall McLuhan. So the medium is the message. So this is really important with social media. Social media, can be accessed from virtually anywhere. It's far more quickly. It's often used to distribute information and opinions very quickly. So that means that it's used without considering the permanence of what's being posted or sent or the content itself. Posts are prone to being forwarded easily by others. They can be screenshot. So you don't have control over how they are distributed once they are out there. And then parts can be distributed selectively. I'm going to go to, by distributed selectively, I'm going to go to this fairly recent example. It happened last year. Dove Soap. Dove Soap had this campaign where it had a long video, well, not a long video, but maybe a 30-second video of different shades of women, so dark-skinned women, and medium-toned women, and a light-skinned woman taking shirts off, and I don't know what the purpose. We're all changing shirts and then becoming a different woman, and it was for their soap. But what went viral about this campaign was this screenshot. And this screenshot basically showed a dark-skinned woman taking off a t-shirt, becoming a light-skinned woman, and advertising Dove Soap. And the response was, what is this? Like, that's a weird message to be communicating. Why are you communicating like this message? But no one really saw the full video, which is actually much more innocuous and not offensive. They saw this, and Dove had to apologize. And it's not because they actually intended to communicate this, but what was taken from this and what was parsed out and cut and distributed in a viral way was this message. So now we're going to go to a poll, and I hope that this works for everyone. And so the question is, which type of defamatory post would be more serious? Post on Twitter, a post on a website with member-only access, or a post on a newspaper publication in a national newspaper? So I'll give you guys a few minutes, well, a few seconds, not a few minutes. And we'll do the results. So the results are 64% said a post on Twitter, 0% said a post on a website with member-only access, and 36% said a newspaper publication in a national newspaper. And this is a little bit of a trick question, but it's interesting that no one said a post on a website with member-only access. And the reason why that's interesting is that, again, even if you post something on a private website, there is very little control about how that post may be screenshot or downloaded and then redistributed. So again, it's not necessarily the safest option, but I think that the majority are correct. A post on Twitter would probably be more serious in terms of the impact that it has in terms of being disseminated on a global basis. Here's what the courts have said about social media and internet posts. So posts on the internet have tremendous power to cause instantaneous and irreparable damage. Messages can be forwarded and reposted even after you remove a website or a post. So it is impossible to erase the damage that they caused when they were published. Again, so going back to that members-only website, a post there, despite being private, can be forwarded and reposted in ways through technology, through screenshots, and cause more damage than the poster ever really intended. And then courts have actually found that the anonymous nature of communications create a greater risk that be believed. Now, whether or not this comment by the courts will stay true as people become more media literate is another story. But, in this day and age, at this time, this is what courts have decided, is that anonymous communications actually create a greater risk of messages being believed than communications that are not anonymous. And so then you get into, what if you haven't actually posted anything? Well, you can still be liable. So it can be enough that you have provided, operated, or administered a website that others can post to, or to repost statements originally posted by somebody else. And there is also an element of vicarious liability as an organization that you may have if you have an employee or a volunteer who is responsible for social media and posts something on behalf of the organization. Courts will consider whether the act that was done was related to conduct that is authorized by the organization, and if the organization doesn't have a policy in place or has created an enhanced risk that something wrong or improper can be posted, then it could be found liable for that post and any invasion of privacy or defamation that might come from that post, even though the organization didn't necessarily sign off on it or post it. And vicarious liability, again, is something that attaches equally to nonprofit and for-profit organizations, and it can apply to your organization's volunteers. So it's also really important to keep that in mind if you're having volunteers operate your social media account. And then that's called a concerted action liability that courts have found as well. And this is where one of the potential defendants does not publicly approve or repeat defamatory statements, so approve a post or repeat the statements made in the post. This doesn't necessarily absolve them of liability. Where there's evidence to support that there's a common design, so the organization and the individuals who actually did the post were working together or cooperating to cause the harm that was created by the post, then an organization could also be found liable. Okay, and then we get to, but what if you never intended the message to be distributed? And back to our private website. So you can be, and again, courts have accepted that the individual posting content online or sharing it electronically should know that a post on a social media or blog can be circulated widely. So if you use social media to post something, part of using it is knowing that this potential circulation, widespread global circulation, can happen. And the extent of the damage will involve a consideration of how widely the message was distributed and to whom. So even if you only intended the message to be limited to a small segment of the population, once it's distributed widely, that would influence how much damage was actually done by posting the defamatory message or the message that invaded somebody's privacy, for instance. And then again, I want to just go back to the Rouge Valley Co-op case that I discussed. And, in that case specifically, the board members that were found liable did not intend for messages to be distributed at all. And they didn't even know who distributed messages that were, deemed to be so vicious and inappropriate. But because they didn't do enough to prevent their distribution, they were found liable by the Human Rights Tribunal for failing to prevent the harassment that those members experienced. Then does that mean that you can't post anything negative? No, and definitely one of the core principles of the Canadian Charter of Human Rights is that you have freedom of expression. And certainly no one wants to limit that, but what courts have said is that there needs to be a balance. There needs to be a balance to protect someone's privacy or to protect their reputation or, health code. So you need to balance what you're posting with kind of the impact that it would have on others where you're posting something negative. There are also defenses that you can benefit from, and I mentioned a few of them earlier, defenses to defamatory statements. So these defenses include justification. Justification just means that it's the truth. So if you post something that is negative and defamatory, which means that it's harmful to someone's reputation, if it's true, then it's a full defense to the defamatory statement, and you are not going to be liable for that. Fair comment. So again, I mentioned that if you make a comment that's negative, that doesn't necessarily mean that you're going to be liable for defamation. And that's because you can make a comment as long as it's based on true facts and as long as it's fair, meaning that it's balanced. It's not something that is very extreme based on. The key here is that the facts must be known to the people that are receiving your fair comment post. So if you know a bunch of facts and you don't share those facts and just make a comment that is negative and defamatory, unless the facts are notorious, meaning that they're very obvious to everyone who's reading this comment, you could be on the hook for defamation. So the fair comment defense is tricky in that you really need to make sure that you communicate the facts that you're basing your comment on, unless they are so notorious that you know that everyone is aware of those facts. Like the sky is blue. Great, if you make a comment about the sky being blue based on the fact that the sky is blue, then that, obviously is a notorious fact. The third is it was communicated responsibly, and this generally applies to individuals who are writing newspaper articles or blog posts, and there's a whole long set of factors that are considered when you're benefiting from this responsible communication defense. And I'm not going to get into that because generally organizations probably wouldn't benefit from this defense, but it is one that is available. And then qualified privilege. So qualified privilege is often relied upon in political campaigns or where you're complaining to a governing authority or to the police, or where there's, an internal election or member dispute in an organization, qualified privilege may apply. And it basically just allows individuals to make statements that could potentially be defamatory, but they're protected by essentially this privilege, which is essentially a sphere where you can make comments that are meant for a certain subset of the population to make a decision based on. Now, the key here is that the defamatory statements must only be communicated to those who have an interest in receiving them. So if you're going to use a qualified privilege defense to, rely on a qualified privilege defense to post something negative on social media, you're probably not going to be successful because it's not going to be communicated only to those who have an interest in receiving the communication. It will be communicated more broadly. So qualified privilege defenses, unless it is, like the federal election that Canada is going through, will almost never be available if the post has happened on a social media account. So now that I've scared you all in not wanting to use social media, obviously social media is very important and organizations do need to use it out of necessity these days and should, and there are tips that you can do to protect your organization to make sure that you don't fall into these legal traps. The first tip is be careful and thoughtful about what is posted. And when I do this presentation in person, I like asking how many of you have ever posted something that you later regretted posting or perhaps thought you shouldn't have posted. Those are probably questions you should ask before you post anything. Because even if you post something and then you regret it and delete it, you, again, don't know how much that post was circulated prior to it being deleted. You took a picture of it and saved it somewhere to distribute it later, perhaps. You don't know how many people just saw it before it was deleted and the impact that has had. So it's really important to be thoughtful and careful about what's posted and make sure that it actually has a purpose for your organization and for what you want to communicate to the public. Have clear internal policies about social media use, content, approval of posts, and sharing of outside information. Internal policies are really important, and they can set out, one, who is allowed to access social media to post things, what's the scope of content? So are you just allowing anything to be posted? Must it be related to one issue that the organization is dealing with? Does it have to be related to the activities that the organization carries out? Need approval. What kinds of posts might need approval, and what kind of posts are you okay just leaving in the discretion of the person who is handling the social media content? And then what kind of outside information can you recreate on your social media site? So again, you want to make sure that you're not posting something from an outside content that is defamatory, because that could bring liability to your organization. It is possible where you're not just sharing a hyperlink, but sharing part of an article that if there's defamatory content in that article or in that outside post, that you're then liable for republishing the content. So you want to be really clear about that outside content. You want to make sure that you fully read all of the outside content if you're posting part of it or reposting part of it on your social media page, so you understand what's in there and understand if there's anything questionable that would make you think twice about sharing that outside information on your organization's social media. Segregate personal and professional social media accounts. So one, make sure you don't mix up where you're posting. So if you have a personal account and a professional account, obviously you might post very different content on your personal account and your professional account, and you shouldn't mix up what you're posting on which, because that could create a lot of problems for your organization. If you have someone posting for your organization that is really the face of the organization, you may want to put controls in place and clear expectations around how they're expected to use their social media, their private social media. And you might want to ensure that their private social media is actually private, meaning that it's not open to the public the way that the organization's social media. Okay, and then if your platform is participatory, meaning that you allow people to post things, so people outside your organization to post things, or leave comments, that you have a code of conduct for participants so that they understand their behavior and what's acceptable behavior and what could get them removed from being able to participate. Because when you want to have a fair process to allow individuals to participate and not feel targeted if they're removed from participating. But you also want to have something in place for other people who could potentially be negatively impacted by those other participants and their use of your social media page or platform. You want to have something in place for them to speak up to, police behavior and to make sure that everyone operates and behaves in a way that is respectful of other people who are also using the platform. Okay, and then if you allow comments and posts from members or the public, monitor the accounts closely. I think that the first question that you really need to ask if you're going to allow comments is what benefit does your organization have from allowing comments? Now, you'll see that a lot of newspapers now have actually gotten rid of allowing comments on articles for the very reason that a lot of defamatory comments actually happen in the comment section. And again, you could be liable for providing the platform that allowed those comments to be published. If it's important to your organization to allow individual media posts, you have to have someone monitoring those comments. So if someone makes a defamatory or discriminatory comment or posts something that invades someone's privacy and it's left on the site for a long period of time, then this, one, provides a further opportunity for posts to circulate and do more damage, and also provides a further opportunity for the comment to be seen by more people and, again, do more damage. So, it's really important that if you are allowing comments and posts that there is a constant monitoring. So someone who is monitoring those posts and those comments and making sure that they're in line with the organization's policies and what is acceptable to be posted. Okay, and then finally, and specifically for the Ottawa case, make sure that the individuals appearing in photos and videos that you have captured and posted actually consented. And I don't think that this necessarily means that you need their consent in writing, but if you are taking pictures in a public place or taking pictures at a public event, you should at least make people aware that you will be doing this and have them tell you if they don't want their image to be captured or used in any way, because it's really, one, respectful and proactive in terms of protecting your own liability if an image is posted that someone did not necessarily consent to having posted. And so again, this really, it goes without saying that even if their image is captured in a public place or at a public event, that doesn't necessarily mean that they're waiving their rights to privacy and how that image is used. So that's actually it. And I didn't get very many questions. I thought there would be more. So if you have questions, you can answer them now. Are there any tips for social media advertising? So I think for social media advertising, it might be a separate presentation too, because you obviously want to comply with the CAFA legislation, so the anti-spam legislation. But again, for social media advertising, I think a lot of that is more about what reputational impact your advertising might have. We mostly work with nonprofits and co-ops, so I don't have a lot of that, but certainly your obligations under the anti-spam legislation would be really important in that respect. In terms of drafting internal policies, should we incorporate the legal concerns in the, I don't know what M is, but I'm assuming, should you incorporate legal concerns in the policy itself? So when you're drafting internal policy, should you incorporate the legal concerns? Generally the policy should be designed to address the specific legal issues that could arise while using social media. I don't think you need to incorporate the specific legal terminology, though. Policies generally should be plain language and fairly accessible, and getting heavy into the legal detail kind of gets ahead of the point of the policy. You want it to be an effective guideline for people who are using social media, and it should obviously be drafted taking into account all these areas of potential liability, but you don't want it to be a legal document. You don't want to create the legislation in your policy. That's not really what the purpose of a policy would be. And then, do you have templates policy for social media use? I'm sure we do, and but I would need to look into that. And if I can find something that I think could be helpful for you guys, I'll circulate it with the presentation. Do you have examples of co-ops that have a successful social media presence? So I know that Peel Region, the Co-op Federation of Peel Region, has worked with a lot of co-ops to design social media platforms and create that social media presence. Certainly there are co-ops, so On Co-op for one, Solar Share, a variety of social media presence. In terms of housing co-ops, I think that that's something that an up-and-coming area for business development that certainly the Co-op Federation of Canada, CHFT, and Peel Region are working on. Do you have a template for a code of conduct for participants? So again, the template for the code of conduct would really depend on what what the purpose of your site is and what kind of comments you're allowing. So this does need to be something that's a little bit tailored to what you're going to be using your social media page for, what you're going to be posting, and what kinds of people will have access to comment on. But certainly your code of conduct is generally, you'd see it in anything that you do, even in code of conduct for board director meetings and things like that. You be respectful, you don't say anything that's racist, discriminatory in any way, you don't use violent language. There are some basic things that you always include in these kinds of things, but it should be tailored to exactly what the platform is that you're allowing comments on. So a public event where photos will be taken and possibly posted, is consent implied on your part? I would say no, but I think that this is an area for legal debate that, it really depends, I think, ultimately on the ultimate use of those photos. So again, as we saw in the Ottawa case, that the court in that case really focused on the fact that it was being used for profit. That might not necessarily be the case where it's a public event where photos are being taken, for artistic purposes or to, like an event or person taken. But I think that at all times it's important to have a disclaimer, personally, to limit risk, just saying if you don't want your photo taken, you can stand in this area that is going to be private and out of the view of the camera, or you can come speak to a person about that. I think that that's just a good practice and limits risk. Do you have a template for permission to use photos and videos? We do. So I think anyone asking for templates should just contact us directly, and we can see what we can help you with, because we need a little bit more information. But yes, we would have templates for these kinds of things. If a company uses social media to promote events and updates and requests staff to support in sharing company events in their own social media, is that generally okay? So there are a few things that be aware of if that's the case. I think that you need to have a discussion internally if your organization is asking employees to share something on social media on their own private accounts on behalf of the organization. Do you have any concerns about what's being posted on their account? Do you even want involvement on what's being posted on their accounts? Do you have kind of a employment policy in place which addresses kind of what employees do in their private life and, the impact on the reputation of the organization? So I think those are all important questions to ask when you're asking an employee to support an event on their own social media page. I think if you don't have any of these concerns and the employee is generally supportive, I wouldn't see a problem. But again, there's still a distinction the employee's private life and then their more public role in the organization. So you need to make sure that you've navigated that properly and understand anything that could potentially arise by asking them to make that post on their private social media. Okay, I think that's it. So you have a little bit more time for your lunch, and I hope you guys enjoyed that, and we will send out a copy of the presentation with you with contact information in case you have any follow-up questions as well. Thank you. Have a great afternoon.